You know, I saw this picture a few months ago and I thought to myself, yeah, that's really cool. And it's like really scary. It's kind of like spooky. Like what is he feeling? But I'll tell you what, I've seen that look before on humans, right? I feel like it's the look of terror. That's why I always call it having whale eyes because it's like, I don't know if it's the adrenaline or if it's the anxiety, but something causes them eyes to just light up. You see it in dogs. I'm, I'm looking at my dog as if you could see her. You see it in dogs. You see it in humans. You know what I mean? And today, ladies and gentlemen, we're covering Stephan Stearns. Stephan Diddler Stearns. What a fucking piece of shit, right? He walks out and looks directly at the camera because he cares about his image. I know a lot of people care about their image when they're in jail and they're facing things, but Stephan has a specific care about what people think about him. He looks straight toward the camera. And what did you see? Nothing but some whale eyes. You know what I'm saying? You can see the terror in his eyes. I don't know if it's terror of people finding more out about him in trial. I don't know if it's terror that he's going to be in there for the rest of his fucking life, for the rest of his natural life. You know? I don't know what it is, but he's experiencing it. And he's got a nice little haircut. So let's go ahead and check this thing out, man. I like this judge. Defense is just doing their job. So they're trying to suppress everything. They're trying to keep the cameras out. They're trying to do all this bullshit. I like the judge. The judge is not going for none of that. Suppressed, denied, suppressed. That's all. I mean, denied to suppression to everything. That's all we've been hearing every outing for Stephan Stearns. But let's go ahead and check this thing out. Just in those couple of seconds, he walks in. Let's back it up. Man, a lot of people I notice, they don't really look at the camera. They're kind of more focused about like what's going on, how I'm going to get out of this. They're focusing. Stephan goes straight for the camera, bro. That's all he cares about is public perception. What a bitch. I hope his mommy has been telling him about what's been happening. And apparently there's some text messages with certain YouTubers where she's trying to defend him over text message. So we're going to cover that eventually as well.
We're on the record, State of Florida versus Stephen Michael Stearns, 2024 CF 632. Appearances for the record, please.
Danielle Pinnell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Stearns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has case law provided a copy to the state already. You want me to give you a moment to read, Judge, or you want me to start?
Just a moment.
And looking at Stephan, honestly, they probably had lice or something. He had to cut his hair ASAP. I notice a lot of prisoners, when they get in there, that hair gets cut. But if you can tell, I feel like he's gained a little bit of weight. And I feel like the fear has increased on him. It's like you could feel the anxiety, bro. He doesn't really come out of his cell often. He's probably still calling mom and dad all the time. I'm waiting for those calls to come out. But, you can tell this man is anxious, bro. Prison is wearing on him.
Do these highlight the McKay factors?
Essentially, Judge, they all essentially stand for the same
I'm
purpose.
familiar with the McKay factors. Thank you.
And the cases that I provided to the court are both from the state, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020, McKay versus State, First DCA 504 Southern 2nd 1280 from 1986. And unpublished opinion that only has a Westlaw site so far, Surratt versus State 2025 Westlaw 1119091 from last week from April of 2025. Trocola versus State 867 Southern 2nd 129 50 CA from 2004, and Singer versus State 286 Southern 3rd 343 of 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress the set for the tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case. And that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in.
Man, she know how to talk, man. That's why I couldn't be an attorney. Holy shit, my brain is trying to keep up, man. Basically, what she's saying is that in clear words, she said that toward the end, they didn't have enough time to investigate some of the information that they want to be added, that the prosecution want added into the trial. But, it's things like that. They tried this shit with the cameras. Now they're just trying to get any type of evidence, I feel like, that they can removed. And I feel like enough has been removed already. The judge's not going for that, bro. It's almost trial time. I think it's May, right? Time's coming close, and I feel like they're just trying their best to muddy the water the best they can. Doing what defense does. I know this woman, and she's a woman too. Man, I know she probably have kids too. I know she's disgusted standing next to this fucking clown. But hey, defense is defense. But let's continue.
Believe Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion, as well as in preparing the other case for trial. Defense is coming to information that at this time defense is in a position to be able to divulge to the court.
Oh, yes, because the first one is going to be for the images. So he's double fucked. Hold on, let's look it up real quick. Okay, so Fox 35 says Stearns is charged with first-degree murder and the death of the girl. He is also charged with a separate case with some 60 counts of SA and possession of child SA material after thousands of graphic photos, some including Maddie, were found on his cell phone and saved to Google Drive, court records said. Okay, so that is what I believe is coming first. Listen, they're going to double fry. The deep fried Oreos and shit, they're going to double fry his shit. They're going to go crazy on him. And there's even some more information I wanted to point out. So the suppression hearing was set for Wednesday, right? It's Tuesday now. It says what we know. The suppression hearing scheduled for Wednesday comes after Stearns' public defender asked a judge to bar jurors from seeing evidence collected from Stearns' phone and Google account due to investigators allegedly unlawfully seizing and searching his phone. However, prosecution claims that Stearns gave consent and the evidence from both the phone and Google account were properly obtained. Bro, if you remember those phone calls, we all heard Stephan say, I erased my phone by accident, but you could use it. He willingly gave them that phone, okay? But again, they're trying to murky up the water because that trial's getting closer. Man, listen, this is going to be another Valo situation to where when you go to your second trial, you're fucked no matter what. Damned if you do, damned if you don't. Damned if you win, damned if you don't, because Stephan will have to win both of these trials to, in my opinion, stay out of jail for the rest of his life, which is never going to happen. So let's continue.
Or in open court.
So your good cause is secret?
Essentially, Judge. Well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense. or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of the homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case.
I mean, she's working with nothing here in the first place, but you can't come to the court and say we're not done yet after a year. You know what I mean? Like, I don't think that flies. Like, we're not done. But listen, I don't care at a certain point. Like, a lot of people, a lot of strategy, obviously for good reason, is delay as much as fucking possible. P. Diddy just got denied his trial for being delayed. What were they trying to do? They're trying to delay that shit. At a certain point, the judge is just going to say, no, you had enough time.
If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would going to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We were able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing the Beaufort factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing the motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
All right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information.
You know what I didn't mention or I didn't think about? He has a public defender. They said that twice. This is a public defender. I thought the family would have purchased a good lawyer for him. You know, not saying that public defenders are not good lawyers, but I'm just saying public defenders have different loads. You know, they're public defenders. You know what I mean? Like they're dealing with your case, they're dealing with this motherfucker's case, they're dealing with that motherfucker. You know, you're just a number. Well, let me not just say all public, but not all public defenders. But I'm just saying there's a lot more load on them. Where's all that family money? Because apparently they had money, right? Why aren't they pouring their support into their son? Because they know that motherfucker is guilty. Why would you waste your money on something that's going to break anyway, or something that's going to go to jail? You know, I wouldn't waste my money on that shit either. That's a bad financial decision.
Was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing.
Sounds like a whole bunch of bullshit to me, you know? And I mean, this is where I feel like this is where cases go to trial because, you know, first the trial date gets set, then it gets pushed back, then we argue, then we push it back again, then we push it back maybe a second or a third time. But then it gets to a point to where defense starts to throw out bullshit to buy more time, and then the judge just says no. I think we've gotten to that moment where the judge is just going to be like, okay, you guys are clearly just out here trying to buy time for whatever reason. Let's do this thing.
The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge, defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of, to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense will be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed, discovery exhibits haven't been disclosed in regards to it, because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue, and then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there has been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March.
See, the motion was, it's too much time, you know? And you're trying to get a continuance to the motion just because you want more time to dig up some bullshit. It's not, they're trying to find a technicality, because when it gets down to this type of a situation, when this person's fucked, all you can try to do is find the technicality, you know? So there's just, give us more time. Give us a continuance on the continuance's continuance is what they're really trying to say. Oh, this trial is going to be interesting. For the CSAM, I mean, for the pictures and the photos with Stephan Stearns, I think that trial is going to be really quick. There's no defense. Like, what are you going to say? I accidentally got the pictures. Like, that's going to be clear cut, done over. And then the real trial begins for that murder trial. So that's the one I really want to pay attention to. But I think we're going to find out a lot about the murder trial through this one. But let us continue.
13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has
They won't share it because it's nothingness. That's the point I'm trying to get across. They don't want to share it even though it's ex parte because there's nothingness. That's why they're not sharing. It's a tactic, and it's a damn good one, because sometimes this could float you over for years, right? I can't think of an example, but what's a good example? Young Thug's trial was more because jury selection, and then the judge got recused. Young Thug's a good example of stalling for time and it working. Who's a good? I can't think. Young Thug is different though, because that trial was botched from the start. You know, that judge should have never sat down. Like, Young Thug should have been free the second that whole. Anyways, I'm talking about a whole different trial, but Young Thug should have never even went to trial, in my opinion, because that prosecution was so ass. But all I'm saying is it's a tried and true method, I feel like, to stall time.
Requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming, are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you. Matter set for 3 hours tomorrow at 2 p.m. That will conclude our hearing.
This time he walked by and didn't look. He didn't look because, oh my God. And look at his ID, bro. You see his ID has that scary, spooky eye mugshot, bro. Oh my goodness. I'm going to show you what his ID has right there if you can't see it from that angle. Hold on. Ha! They have that spooky ass whale eye mugshot. You see those eyes? That's terror, bro. That is terror. Okay? Get to know the look, because you're going to see a lot of it on Stephan's face during these trials. Get comfortable with it. Just like looking at that whale. Just go on Google and look at a bunch of whales. Start getting comfortable with the idea, because Stephan's going to be looking like this the whole trial. Terrified like a little bitch. But I'll see you guys soon. Stay inside, stay safe. Shout out all the new subscribers. I love you guys. I'll be back very soon. Goodbye.